turnout today. I don't know the total number of participants, but if somebody could maybe put that in our closing, I'd love to see the total number. That would be awesome. Okay, let's start with our first question. Let's see. It's from a president of an association. Please tell us what will happen if we cannot get enough people to have a board. Well, the scary reality of that is if you can't get people to have a board, you're going to have a receiver appointed to run the affairs of your association. So that's scary. That's not an outcome that you want for your association. If you're in this situation right now, reach out to our firm. We can help you. We have a letter that we send on our letterhead to all owners. You can disseminate it. We just write the letter. And basically we explain to them, this is what happens if people don't run for the board and we don't have enough people to have a quorum of the board. And the court will appoint a receiver to run the association. The first thing the receiver is going to do is they're going to, levy a special assessment that the court's going to approve. That says that, each owner must pay for the receiver. So it's like not even paying for an improvement to your community. It's just paying a receiver to run the association. So in addition to it costing more for everybody to have a receiver, it's also going to affect your property values, because how are you going to be able to sell your property if it's, a court-appointed receiver is needed to run it? It's just not a good situation for anybody. Okay, the next question. What is the difference between a vote versus a consent to make a change on a community document, such as a CC&R or an amendment? Does Arizona statute require the board to set a time limit to get results from the community members? So great question. So this is a amending CC&Rs question, and the person that's asking this is saying, so what's the difference between using just a ballot voting yes or no versus a consent form, which saying I consent to this amendment? Honestly, there's really not much of a difference. Probably you're using a consent form because your documents, require you to obtain a consent of 75% of your members. That's just a linguistic thing that you're using. Does Arizona statute require a set time limit? No. But, typically what we see is we strategize, like how active are people in your community? Like sometimes I have boards say to me, I think we can get this done in 30 days. And I look at them and I'm like, really? That seems pretty quick. And they say, well, we only have 20 owners and we'll just knock on everybody's door and we've gotten things done quickly in the past. And then maybe 30 days is enough for that community. But for larger communities, we really probably want to set it at somewhere between 3 to 6 to 9 months to get the votes that we need if we have a high percentage of approval that's required and a lot of votes. But there is no Arizona statute that puts a time limit on it. Okay, question 3. Can our entire board conduct a tour of the deinviting the residents? Is it a meeting under the law? I'm not sure I understand that question. Can our entire board conduct a tour of the deinviting the residents? I'm sorry, I don't know what you mean by that. So if you're still on, submit in through the Q&A box a clarification on that and I'll answer it at the end. Okay, question number 4. Our CC&Rs and rules and regs do not address a homeowner who wants to put flooring and a gazebo on his roof. How do we address? Well, if I had to guess, I don't know if you're a condo or a planned community, but one of the things that I would say that how I would address this is I would make that person submit an architectural approval, and I would require that person to obtain, a written report from engineer saying whether or not the load, the roof could take the load. I mean, I think you can also consider this like, hey, is this something that we want in our community? Like, is this something once we allow this, if you do allow this, is it something that we'd be okay with? It's 50% of our owners had it. So, just some things to think about. This should be done through the architectural process. You may need to talk to your attorney. You're welcome to reach out to our firm if you have questions on this, just to determine like, hey, is this something that we really want? And if it isn't, how are we going to word the disapproval so that we're protected if the owner challenges it? Okay, next question. What if they post the 48 hours advance notice of the meeting and agenda on their website and I don't see it? Well, let's go back up to the law. I think that it gives many different ways where you can post the agenda. It can be by hand delivery, mail, website, email, or other electronic means. So it's pretty open-ended how they can post the, the agenda and the notice of meeting. So as long as they comply with that, you just need to be checking frequently if you're interested in association issues so you don't miss anything. But if you miss it, there's really the association's not at fault that they complied with how they posted it in accordance with Arizona law. Okay, question number 6. Assume an HOA that is seeking bids from contractors for major repairs to common area property that are motivated by safety and security concerns. So you've got an HOA looking for bids. They had a major common area repair because this repair is needed because there's health and safety issues. Got it. A majority of members object to the repairs. Okay. Assume that the objecting members contact bidding contractors, in attempt to dissuade bidding and attempt to intimidate on-site contractors to delay or stop work. Ooh, this sounds like a lot of dysfunction. So we've got the board getting bids for something that really needs to be done because it's a health and safety concern. We've got a group of homeowners who don't want it, who are like creating a disruption by, telling people not to bid on it and then, interfering with contractors that come on site. Okay, probably what's happening here, if I had to guess, is that nobody wants to come on your property because they don't want to deal with this. They don't want to do the work because it is, a problem. So you're saying now, further assume many contractors decline to bid because of the members' interference. To what extent, if any, do such members have legal exposure in the event of harm to other members by reason of incomplete safety and security repairs? So, probably no legal I'm sorry to say this, but probably no legal exposure if somebody, gets hurt because there's a big crack in the tennis court, right? The board's going to have legal exposure, but not the person that, is creating all this interference in the association's property. I think the bigger question is, why aren't you as a board sending cease and desist letters to these owners who are creating all these problems? I think that would be a good idea here. They really have no right to do that. They're interfering with the contract and they're legally, it's an issue legally for them to be doing this. And as a board, I think, you probably do need to get some legal advice because you really do need to address these issues in terms of the health and safety issues and then the problem homeowners who are harassing the contractors. And I'd guess it, but they're harassing the board too. So reach out to us. We'd be happy to help you with this. We've helped many associations with problems like this. And I can assure you, we can give you the tips and tools that you need to make this a much better situation. Okay, question number 7, regarding the form to comply with the Corporate Transparency Act. Did I read somewhere that only one board member's info will need to be recorded on the form if the board gives approval at an open board meeting? We do not agree with that. It's all board members' information needs to be submitted. I'm not aware of any sort of loophole that just says it's one board member. Question number 8. Is there a common or average amount homeowners are forced to pay of an insurance deductible? And doesn't the HOA have to pay the portion that is common property? So if I had to guess, you're probably in a condominium, based upon the language of the question. There isn't really a common or average amount owners are forced to pay at the deductible. I mean, we just look at it on a case-by-case basis. Like, if, let's say you have a fire, you're in a condo, you have a fire inside your unit, and there's a $10,000 deductible on the association's policy because in a condo, the association's insurance is going to be primary, and then your insurance is going to be secondary, likely from the paint end. It's going to be your responsibility. So, typically what will happen is if it's your fault for the fire, and the association is in no way responsible, you're going to pay 100% of the deductible. But if it's something different, like let's say it's a common area pipe in the wall that bursts, adjacent to your condo, it's not in the airspace of your condo, you aren't required to maintain it, then the association typically is going to have to pay that deductible. So we just look at the facts and then determine who is going to pay the deductible. In some cases, associations, CC&Rs talk specifically about who pays the deductible and the percentage, but that's very rare. Okay, question number 9. Will your firm handle the CTA filing for HOAs that may not be a client? So yes, we are. And we have many CTA filings for non-clients and for clients right now in our pipeline. Is this a standalone service? Yes. I asked because I'm not sure if the other firms my associations may use will offer this service. So we would be happy to help your association with this. If you reach out to me at B Mulcahy at mulcahylawfirm.com. We can give you the package price for us to file the Corporate Transparency Act paperwork. It's due by December 31st, 2024. And then as part of that package, any changes to your information over the next year, so between January 1st, 2025 to December 31st, 2025, are included in that package price. So it's a smart deal because it's just more time you pay it. We just handle it for a year. Okay, next question. Number 10, we've had our open meeting to maintain control of the public streets in the community, which is a law I talked about earlier. Who or how do we submit the documents that satisfy the HOA to maintain street control? So great question. So I think you need to reach out to our firm because there's a specific process you need to follow. So hopefully you handled the meeting correctly and that you got the votes that you needed at the meeting. And then the next step is to have the board sign a document that's recorded with the Maricopa County Recorder's Office, indicating that you took the vote, that you got the requisite percentage, and you are filing it to comply to continue to be able to enforce, issues with your streets. Okay, number 11, can a condo HOA with a single garages assign parking spaces for each unit based on the number of bedrooms for the unit? So short answer on this is yes, if it's in the CC&Rs. So typically the assignment of the parking spaces is in the CC&Rs, or maybe it's in the owner's deed. But after the fact, doing this is something that would be very difficult, and you would probably need to do an amendment to your documents to do that. Question 12, regarding the new ADU legislation. So like on guest homes or casitas in the back of a property type of thing. What happens when an owner starts construction without the required HOA approval? The construction can be seen from the neighboring property only, but the CC&Rs state that if something can be seen from a street or a neighboring property, it requires HOA approval. ADU was at the framing stage when the neighbor reported it, and attorney told us that we had to be reasonable as the ADU was already so far along. I don't agree with that. I think that at any point in the violation, even if it's built, we've seen cases where a guest house had to be torn down. If the owner had submitted for HOA approval, the board would have unanimously turned it down. So what is to keep owners from proceeding with construction knowing that the HOA potentially has no remedies? So I think the bottom line on your question here is I would pursue this. If it's not something that you would allow, I would tell them to stop. This is a perfect example of one that you should enforce. So I disagree with your current attorney. And I think you need to get a meeting with that owner right away and tell them to cease and desist from building it, and explain to them that they needed permission, have them submit the paperwork, and that the board looks at it. If you deny it, you deny it. Okay, next question, number 13. Is it unlawful for a management company to give the HOA board homeowners emails? We are starting our marketing campaign to vote for our proposed CC&R, our proposed revised CC&Rs, and want to regularly share information. So this is interesting. So the management company is telling the board, I'm not giving you the homeowners' emails. I mean, that is unusual. Okay. I don't know what their position is on this. I'd like to hear from them. But I mean, if you're using the emails in an effort to communicate with the homeowners about the CC&R amendments, I don't see really any issues with that. Maybe they want everything to go through like constant contact through the management company's email system. I could probably understand that. That might be easier. But as board members, you are entitled to receive this information. And as long as you're, contacting them on board business, I think it's fine that you contact them. If any owner says, don't contact me on this anymore, then, you should stop contacting them. Okay, question 14. What can be done about a board with a lack of transparency? Such a difficult situation. We always are preaching to boards, please be transparent. The most successful boards are the ones that communicate the most, that are transparent about problems and successes. It's just such a smarter way, a hassle-free way to run your community. But there are boards that like to hide everything and don't want to tell you things, don't want to give you information, keep you in the dark, and that's really dysfunctional. So what do we do? If we've got a board that has a lack of transparency, you make records requests. You're entitled to do that under the law. They have to provide the records to you within 10 business days. You run for the board yourself. Try to change from within. Potentially, you try to remove the board. On our top 10 cheat sheet, number 6 is the process to remove a board under Arizona law. That's, one way to do it. Another way would be start going to your board meetings and start complaining to the board about the lack of transparency and that this is a concern. Maybe even start a petition about, we feel that the board isn't transparent, and submit it to the board. I think all of these are good suggestions to help the board become aware that, hey, this is an issue and we need to be more open and transparent on things that are going on in our community. Question number 15, do most HOAs have architectural and budget committees? I would say probably it's 50-50. The larger associations are going to have these type of committees. The smaller associations typically have the board operate in these capacities. Question number 16, when officers are elected annually, but there are no changes in directors, does that have to be reported under the CTA? I don't think so. I think it's only if the contact information changes for them. And it wouldn't if there's no change in the directors, so no. Number 17, what about selective enforcement in governing documents? For example, acting against a non-dog owners in favor of dog owners, but not enforcing the CC&Rs that restrict dogs over 20 pounds and allow only one animal per unit. If the homeowner disputes a violation when they were cited by putting down scent deterrents to keep the dogs from pooping in front of their unit. Okay, good question. So what is selective enforcement? It's where the board has 2 violations in front of them and they're pursuing one owner and they're not pursuing another owner. I think maybe you're a little bit different, because I don't think what the situation that you're describing is, you're saying that they are retaliating against you because you put down scent deterrents. So they're violating you for putting out scent deterrents, and I don't know exactly what that is. But I mean, it's your property unless it's toxic. I don't really know what it is. It's kind of something I've never heard of. It seems something that I wouldn't really be recommending, but they're penalizing you for doing that. But they're not enforcing the restrictions on dogs, which means you've got dogs that are over 20 pounds in your community, and some owners have more than one dog, and your documents say only one dog. So I guess what I would suggest to you is this. Communicate with your board about, say, hey, there's these violations and I don't see you pursuing them, and see what they say. Maybe they say some of these are emotional support pets and we are required by the law to allow these dogs. Or maybe they're sight dogs or hearing dogs or, other service animal dogs. I don't know. Maybe the dogs are grandfathered. I don't know, but open the dialogue with the association about that. Also probably as part of that, you may want to be talking with them about your issue. And I, would advise you against doing that. I don't know enough about it. I don't know what a scent deterrent is, but if it's toxic, I can see why they're upset about it. Okay, next question, number 18. For those HOAs that satisfy the 6 criteria of the Corporate Transparency Act's filing exemption for large operating companies, $5 million in annual gross receipts, more than 20 full-time employees, is there any action required by the HOA other than merely not filing the beneficial ownership information? So if you fall into one of the categories that's not subject to the Corporate Transparency Act, you don't have to worry about it. And there's no other requirements other than like filing your taxes that you would be required to do. Let's see. Question number 19. When I introduce capital improvement ideas, there are a few fellow board members who start coming up with the most convoluted what-if scenarios about how someone could get hurt by the improvement and sue the board. I know we are covered by layers of legal protection, but if we hire a licensed and bonded company to build it, are they taking on that risk? I'm not doing anything crazy like adding a roller coaster. Okay, that's a funny question. So you have some ideas about putting in a capital improvement, like let's say pickleball courts. And other people are saying, well, what if someone's hurt by that improvement? Maybe the pickleball court's built in a way that is, gonna potentially owners are gonna get hurt, or maybe they're gonna get hurt using the pickleball court. I mean, it just sounds to me like there is a anti-progress, agenda by some people on your board. I mean, if you're using licensed and bonded contractors and what you're building is a capital improvement that is, something that is going to improve your community, I really don't think that these legal challenges that they're making about risks are holding any water. And I mean, I think what's happening here is they're anti-progress and they don't want to do it. So talk it through with them. Maybe you need to bring in our firm to help you talk it through with them so that we can all get on the same page. Okay, question number 20. Fines and amounts are allowed, but not specifically defined in our CC&Rs. Can we charge them at any time with board approval and without a vote of the member? So fines, so what I said previously in this presentation was that fines are authorized by state law. It doesn't have to be in your CC&Rs. So as long as you follow the procedure under state law, you are entitled to, levy fines against an owner. I don't know what you mean by amounts. Maybe you're thinking about self-help. That would have to be included in your CC&Rs in order to charge that. Okay, question number 21. We have a property management company for the past 5 years that has not done a good job of compliance inspections. So there have been lots of unauthorized ARC changes that have gone unnoticed. When homeowners do submit ARC applications that do not conform to the rules and we deny them, they point to those other owners who have illegally done similar things at their home at an unknown time. How do we enforce the past offenders? It does not seem right that we should have to inherit the sins of past boards who have not performed good oversight on the underperforming property management company. Okay, so the best advice I can give you here is draw a line in the sand. Any violations that have existed more than 3 years, you very likely are not going to be able to enforce those architectural violations. Anything in that window of 0 to 3 years, you can still enforce, and you can still deny them going forward. Like if maybe the violation is somebody's putting sheds, in their property, you can still continue to deny it. The only thing I'm going to say, the caveat is, if 51% of your lots have sheds, and you're now trying to say no new sheds, you can't do that. There's been a substantial disregard of whatever you're trying to do. And so you would have to allow that. Okay, next question, number 22. Are monetary judgments related to fines subject to a 10-year renewal? Great question. Yes, they are. Question number 23. Is it required that a homeowner be informed of who reported a violation against them? Is this a new law? So it's not a new law, but there is a law in the books that says this, that if an owner asks via certified mail for who reported a violation against them, the association is required to notify the owner who requested it by certified mail, who reported the violation or who saw the violation, who witnessed the violation. So yes, there is a law that says that, but there's a specific, like you have to meet the criteria, like you got to send, whoever's asking for it's got to send it by certified mail. Okay, number 24, once you put a member on a payment plan for HOA late dues and they stop paying the payment plan, what are the next steps? So the next steps are just go legal, probably a lawsuit. With the changes in the new legislation, we do not have the liberty of not moving forward quickly anymore. So what we say is one payment plan. If they blow it and they breach it, then you just take the next legal step. Question number 25. It looks like we have, oh my goodness, a number of questions have come in now. We have 44. Question number 25. Is due process or the 21-day requirement notice on each letter sent a requirement before each fine process or only prior to the beginning of the fine tier plan? Additionally, for instance, in a community with a 10-day violation compliance timeframe, we would send a courtesy notice, and then with all information such as who cited, date cited, and what part of dock was violated, and include both the verbiage that they have 21 days to attest within the Arizona code, as well as the verbiage regarding the right to attest via ADR and the code, and including a statement that compliance is imperative to avoid the fines. After the 21 days has passed, I'm assuming we could then begin the 10-day enforcement and fine schedule. So do we have to wait the 21 days between each fine after the initial courtesy notice? Okay, you're making this way too complicated. The due process, the 21-day requirement, yes, it's important to have that in the letter, but no, you don't have to wait for the fines to do that. So you can set up your letters in such a way that, you can say, you're going to be fined on this date and give them the notice opportunity to be heard. It can be less than the 21 days. And you don't have to do this big, long, drawn-out process that you're mentioning here. 26. Is it a common practice for applying a reasonable fee for processing submittals to the A.R.C. or appeals to the board? Our CC&Rs apparently allow this. This fee must be paid at the time the request for approval or the appeal is submitted. Your thoughts? So no, it's not common practice. The only time we really see a fee is when it's a new construction on a lot. Maybe it's like a fee to have the architect review it, but this is not a common, fee or process that we see. Question 27, our CC&Rs are almost ineligible, or how about illegible to read. So most homeowners never even look at them. If we pay a contract paralegal to retype the CC&Rs, do we have to get the retyped CC&Rs re-recorded? My view is if they can't read the CC&Rs, homeowners are less likely to comply with them. So no, you don't have to record them, but it might be time for an amendment. Would be my thought. If the ones that are recorded are illegible, really we probably want to do some amendments and then re-record the document. Question 28, Phoenix City Code requires certain requirements for short-term rentals. Can the HOA require renters to show compliance? No, you can't, but you can report them to the city if you think they aren't complying. Question 29, if we can only charge $15 for not providing the tenant information, how can we force them to comply? That's a great question. I mean, that's the only way you can force them to comply. And it's a $25 fee for the application and then $15 if they don't do it. You can sue them, for this fee, but you cannot lien for it. Question 30. Thank you for the class yesterday. Okay, great. Looks like you're doing double yesterday and today with me. I am a homeowner. At your class, you went over what happens when a board member breaches their fiduciary duty to a homeowner. Could you please explain that again? Okay, so a board has a fiduciary responsibility to act in the best interest of the association when they're making their decisions. So if a board member breaches their fiduciary responsibility, really what typically happens is they get sued. And the lawsuit's filed against the association, or maybe the owner goes to the ADRE and files a complaint with the ADRE. Those are typically the things that happen. Or maybe there's a removal petition because the board doesn't want the board, in power anymore in the association. Question 31. We have a board president that has discontinued committees and now says a person can apply for a committee and will be possibly interviewed and will report to a property manager and not the board. What do you recommend? Well, I'd have to look at your documents to see what it says about committees. Like, does the board president have the authority to report committees? I mean, it's hard for me to answer this question without knowing how large your association is. So this is a hard one for me to answer, but I would look at what your documents say about committees and then go from there. Question 32, does the 48-hour agenda rule also apply to committee meetings or just for board of directors meetings? So we've talked about this a lot internally in our firm. It doesn't say it applies to regularly scheduled committee meetings, which would be subject to the open meeting law, right? Probably best practices would be to do it, but I don't think you're required to do it under the language of the new legislation that just went into effect on Saturday. Question 33, does it matter if our association was organized as a condo in 1979, but the units have vertical ownership, just lot number in the subdivision, but the CC&Rs refer to each unit as a condominium? Do the planned community laws not apply to our association? I'd have to look at your documents to answer that question. It sounds like it's going to kind of depend who owns the common areas, but it sounds like even though you're called a condo, you might be considered a planned community. But I'd have to check the documents to look at that. Okay, number 34, is there an application fee for the Corporate Transparency Act? Short answer, no. No application fee to the government. But we do charge as a firm a fee to do the paperwork for you. Question number 35, in a condo, can one owner divert or eliminate another owner's access to their main shutoff valve? Each owner has an individual main shutoff valve. To turn off water, one owner must ask for permission to cut off another's water. So, except in an emergency circumstance, there really should not be a situation where, the owners whose water is being cut off is not notified. Question number 36, can you require a landlord to show the board that the renter has renter's insurance in case they damage their neighbor's property? So under Arizona law, no. Under your documents, no. Number 37, I was charged a billing fee and a late fee for missing a quarterly payment. I understand a late fee, but is a billing fee legal? So this is a good question. So it just depends. Is it in your documents that they can charge this? That would be the question that I would ask. If I had to guess, it's probably not in there. It's probably an add-on fee that the management company is charging. It might be considered a collection cost under the law, and they might be able to collect it that way and lien for it that way. Question number 38. By the time an abandoned home went to sheriff's sale, it took years. Then at the last minute, the owner paid up. So now it's still abandoned. Can this process go on and on? I think it shouldn't take years to get to a sheriff's sale. I mean, if you're handling it in a proper manner, I mean, it depends. If the owner was, if there was the lawsuit had the owner hired an attorney and there was, a lot of motions and we had to have a trial, it could take years. But most of these sheriff's sale type foreclosure lawsuits are handled in like 9 to 12 months. I really think maybe you need to change, think about a change in terms of how you approach the last one. Maybe reach out to our firm. We look at a credit evaluation and come up with a different plan, because it appears that what you did, where they brought it current, but now they're not paying again, it didn't work. So we need to come up with what our new plan is to get them to pay. Okay, number 39, is it beneficial to file a notice of violation prior to going to the DRE? I would say yes. I mean, I think that sending out a violation letter is a good idea. Now, by notice of violation, I don't mean like, are you recording something? I'd have to see if that's authorized in your documents before I could suggest that you do something like that. Question number 40, can our entire board conduct a tour of our development to take note of conditions without inviting the residents? Is it a meeting under the law? So short answer would be yes. If a majority of your board is meeting to do property inspections and you're talking about association business, which sounds like you are, you would have to notify your members and make it an open board meeting. Question number 41. Does the law on solar panels apply to condos or just planned communities? We want to know if the law supersedes the CC&Rs when they state the homeowner cannot make alterations without approval. So great question. So there's several laws on solar panels and associations. One is the one you cited, 33-1816, which applies to planned communities. So that particular statute does not apply to condos. But there's another one that I think it's like 33-346, something like that, that does apply to condominiums. So what I would recommend you do is, if you are a condominium or a townhome and you have an owner that wants to put the solar energy device on the roof, you need to reach out to an attorney to help you with that. If the roof is maintained, by the association, you probably have the legal authority to deny it. But we want to look at it on a case-by-case basis, because what the law says is that we can't do anything to effectively prohibit the installation of a solar energy device. So if, in a condo, the roof is going to be held in common by all owners, so the owner doesn't own it. So it's typically an argument that we can make is that we maintain it as the association. You don't own the roof, and so therefore you can't have it. But again, we got to look at the facts on a case-by-case basis, because in your particular situation, you may own your roof and you may maintain it, even though you're a condo, and then we probably would have to allow you to have it. Next question, we're down to our last four. How can an HOA be run without a secretary? Well, usually we have to have officer positions filled. If you don't have the secretary position filled, maybe you could have like secretary treasurer or president secretary, have one person handling two responsibilities. Maybe the management company can step in and do the acting responsibilities of the secretary. But best case scenario would be to actually have a secretary, because they're important in that they help take the meeting minutes and they help maintain the records of the association. Question 43, can the individual vote record for board election be made transparent and open for all members to view if requested? Absolutely, and you're entitled to see the ballots too. Number 44, can the individual vote, Can a board add or change violations and amounts and fine schedules without a vote or approval of the members? So yes, they could do that at a board meeting. Last question, for the CTA, is it all board members or only officers that need to submit the information? It's all board members, is what the law says. Okay, we are finished. Thank you so much for being here today. Really appreciate you taking the time out of your day to make your community better. Just some quick reminders regarding some upcoming events. So we have our live First Friday event where you can listen in via Facebook Live or on Zoom and ask to have one question answered for your association. That is going to be October 4th, Friday, October 4th at 9 a.m. You can find out information on that on our website. We have an in-person class with the Scottsdale Neighborhood College on October 7th from 1 to 3 p.m. The topic is how to effectively work with management companies. You can find information on that on our website at mulcahylawfirm.com. And last but not least, our next class, number 10 in our series of classes for 2024, our October class, is going to be on, for our virtual HOA Academy, is going to be on October 15th at 11 a.m. And the topic is going to be, we're going to do another little look at the legislative updates for this year, quick little primer on that. We're going to talk about federal laws and preventing crime and limiting liability in associations. So that class, we're going to have a lot of good topics. So hope you join us. Thank you so much for being here today. Lastly, I would ask if you would be willing to do so to please consider leaving our firm a Google review and or a Yelp review. We're sharing a link in the chat on how to leave a review. We like to get feedback from you on these classes and how we can do better, or if we're doing a great job and you like them. It's really important for us to get feedback, and the best way to do that is by doing a Google review or a Yelp review, so we can share that with my team and also with the different cities that we work with so that they know that these classes are worthwhile and we want to keep having them. So thank you so much for being here today. Have a great rest of September. It's finally starting to cool off. Yesterday was the first day, I think the high was 97. So happy to hear that. And we are moving forward to the best time of the year in Arizona. So look forward to seeing you at future events in September and October. And thank you for being here today. Take care.